darkest the people, but the Lord shall arise upon thee, and his glory shall be seen upon thee, and his glory shall be seen upon thee. And the Gentiles shall come to thy light, and kings to the brightness of thy rising. The people that walked in darkness, that walked in darkness. The people that walked in darkness have seen a great light, have seen a great light. The people that walked in darkness have seen a great light. The people that walked in darkness, that walked in darkness. The people that walked in darkness have seen a great light, have seen a great light, a great light, have seen a great light. And they that dwell in the land of the shadow of death, and they that dwell in the land, that dwell in the land of the shadow of death, upon them hath the light shined, and they that dwell in the land of the shadow of death, upon them hath the light shined, upon them hath the light shined.
Mr. Semakade Chimaze Isaac, the President of the Radical New Bar, council members are present and online, the members of Uganda Law Society present and online, the public online, our guests today, Mr. Mukoli Trevor, the President of the Uganda Students Association, Ms. Namuleme Angela, the Vice, Mr. Kuganja Jovan Joel, the media, and our staff present. You are welcome. Beg your pardon on Mr. Kuganja Jovan Joel is the Speaker of the Uganda Law Students Association. I welcome you today to the 4th weekly press and public engagement with the Radical and New Bar. Today we have 3 issues to discuss. The first one being the Supreme Court judgment, where we are going to have a sessions of questions and answers. And here we shall have our Vice President, Mr. Asimwe Anthony, take us through. We have the Radical New Bar statement on Tarehe Sita. Tarehe Sita is a Swahili word, means the 6th day. Then we are going to have the high-profile case unit launched today. And we shall have Mr. Trevor Mukoli take us through the high-profile case unit. He will tell us what it is and what it means to us and what we are going to do under the high-profile case unit. We shall have Ms. Sheila Triasungura taking us through the statement on Tarehe Sita, which I said is the 6th day of February. I take this opportunity to welcome the Vice President, Mr. Asimwe, to take the podium and address all of us on the Supreme Court judgments, and we'll also handle the sessions of questions and answers. Thank you. You're welcome.
Thank you very much, Madam CEO. Protocol observed. For purposes of not wasting time. Good morning, everyone. Good morning to those who are watching us online. As I've been introduced, my name is Asimwe Anthony, the Vice President of the Radical New Bar. Now, concerning the Supreme Court ruling on the 31st day of January 2025, while in Fort Portal, we did issue a statement and stated our official position as Uganda Law Society on the ruling of the Supreme Court that very day. For purposes of having clear reflection, I'll repeat and go through that statement as it was. Now, this is the ULS official statement on the ruling the Supreme Court ruling on civilian trials in military courts, which we felt was a victory for constitutionalism and the rule of law in the country. The Uganda Law Society welcomes the Supreme Court judgment in Attorney General versus Honorable Michael Kabazguruka, filed in 2021, which settles a 25-year judicial rigmarole regarding the trial of civilians in military courts. This ruling, which came 8 months late since the date it was reserved after a rehearing of the appeal on 13th May 2024, marked a crucial victory for constitutional democracy and human rights in Uganda. Justice delayed has been justice denied for countless Ugandans who have suffered under the dark shadow of military justice. The wounds inflicted by this system, particularly in regions like Karamoja, will require more than just judicial proclamations to heal. Pending the perfection of the top court's decree, which we are yet to get, we are impelled by sections 3D and 3E of the Uganda Law Society Act to issue the following guidelines to the state, the bar, and members of the public. Now, this was the guidance to Uganda People's Defense Forces and all security agencies. One was to the immediate compliance with the ruling is non-negotiable. 2, release all civilians currently held for trial in military courts. 3, seize all pending prosecutions in section 1171G and H that have enabled abuse. 4, establish clear jurisdictional boundaries between military and civilian courts. 5, create robust safeguards against future military overreach into civilian justice. To the executive, issue immediate directives to all security agencies ensuring compliance. Secondly, DPP should rapidly weed out from the system cases that are eligible for immediate discharge. 3, establish an interministerial task force to oversee implementation. And 4, provide compensation mechanisms for victims of unconstitutional military action. Now, this ruling must serve as more than just a legal milestone. It must become a catalyst for comprehensive reform, reparations, and guarantee of non-repetition. The pattern of using military courts to intimidate civilians, silence dissent, and circumvent constitutional protections must end definitely. We call upon all stakeholders to recognize that true national security lies not in the expansion of military jurisdiction, but in the strict adherence to constitutional principles and the rule of law. The practice of trying civilians in military courts has been a stain on our democracy, undermining civil liberties and perpetuating a culture of fear and impunity. The ULS now commits to 1, monitoring compliance with this ruling across all state agencies and authorities. 2, providing legal support to affected civilians seeking redress. 3, working with Parliament and civil society on necessary legislative reforms. And 4, maintaining vigilance against any attempts to circumvent this ruling. Now, the Supreme Court's ruling provides a foundation for healing and reform, but the work is far from complete. We must transform its judicial victory into lasting institutional change. The ULS stands ready to support all genuine efforts towards this goal while remaining vigilant against any attempts to undermine or circumvent this historic ruling. The supreme law of Uganda is the Constitution, not military might. Let this ruling mark the beginning of a new era where this principle is not just acknowledged, but properly implemented. For God and my country. That's our statement. Now, as you're aware, this ruling was delivered on the 31st of January, 2025. Unfortunately, it is now upon each and every individual, the individuals who have gone through the court-martial system, the military court systems, those who are in custody, those who are in incarceration, to fight for their own freedom, in execution of the orders of this ruling. Now, the scale of this intervention is so large. We have those individuals who have national attention because they are visible. There are those who have lawyers who can represent them. As the Ugandan Society, our position is that we shall let the members lead those lawyers who are representing individuals who are going through this issue to lead, and we can only give support where necessary. For those that are not visible, those that do not have legal representation, those, the voiceless, as Ugandan Society, we shall lead. We shall take the lead. And that is, we are impelled to do this by virtue of sections 3D and 3E of the Law Society Act. We have a duty, we owe duty to the public. We should also take note that this is not, the scale is so wide. It is not a simple issue. It is so costly. When I talk of taking lead through the Uganda Society, we have systems. We offer legal representation through legal aid. And as you're all aware, our legal aid project is strictly donor funded. The donor funds are strictly meant for particular activities that satisfy the needs of that particular donor. But this process, like I said, it's a wide scale. It is of a wide scale and requires a lot of finances. I mean, we have to traverse the whole country. We've taken steps as Uganda Society. We've written to the relevant authorities. We've already written to prisons authorities to avail us with the details, with the lists and information of those who are in various prisons arising out of the military courts. We've written letters seeking engagement with the relevant stakeholders, like the UPDF, the executive, and the parliament. And we call upon those specific institutions, those specific stakeholders, to take heed and allow this engagement for purposes of ensuring that we bring this to fruition. In terms of the cost, we shall soon be launching a demilitarization fund where we allow members of the public and other stakeholders who have the will and the zeal and they wish to support this cause. That shall come in through soon. Because of the incapacity, the financial incapacity we have. On this note, I'll invite our treasurer to come and say something or add regarding our financial status in as far as our capability to handle this mega activity. Thank you, Treasurer.
Thank you so much, Vice President. I continue to stand on the protocol that has already been laid by the CEO. Good morning, ladies and gentlemen. Good morning, members of the bar that are online and physically present here. Like you all know, recently there was a judgment that was made by the Supreme Court. The judgment was made, but of course there are financial implications that were suffered by a majority of the Ugandans, directly and indirectly. Directly, of course, you know, services of a lawyer are not for free. Imagine the Karamojong, people from Karamojong have to re-incur expenses to hire lawyers. Because now this is going to be a separate matter before the civil courts of law. So that is going to be a challenge, and it's going to have an enormous financial implication on the people that have been tried before those military courts. Yeah, imagine the movement costs that these people have incurred. Yeah, this may sound like as if it is something small, but to the ordinary person, it is something that is so grave. Yeah, this has had an impact on the operational well-being, the business well-being of the people who have been before the military courts of law. People have been taken behind bars and they have lost their work, they have lost their only source of living, because if you are behind bars, of course, definitely you won't be able to work. So that is the plight of such people. In fact, as we speak, they continue to suffer because they are still behind bars. Yeah, they continue to suffer because we understand court made a declaration, it made an order, but they are still there. And of course, this still has a financial connotation to whatever they are going through. So that is how bad the situation is for people that are in such a situation, that are in the ambits currently of the military courts of law. So that is it for the financial part of it. People who are in the military, who have been tried or who are undergoing trial in the military courts of law. I'll also take this opportunity to talk to the members of the bar. Of course, members of the bar need to understand the finances of the society, how the society is doing financially. You all know that the bar is broke. We have been fighting with that situation since we came into office to try to ensure that the bar is brought afloat. We are doing everything within our means. And one of the situations, or one of the remedies that is being brought forward today, it will be unveiled by the President. It's going to be one of the ways in which we can bring back the bar afloat. But that aside, the construction process of Uganda of our house, the Uganda Law Society House, is ongoing. We are making the necessary payments that's supposed to be made. These payments were supposed to be made last year, but they were never made. And of course, the reason was that there were no finances. So we have come in a situation where we have to mobilize funds left, right, and center, cut on some of the expenses to ensure that the house can continue with the process of its being constructed, so that it comes to life. We're only using 2 floors as we speak. And even the floors, some of the facilities are not yet fully put in place. So that is the status as of now concerning the house. I will continue giving weekly updates on the finances of the society. Thank you so much.
All right, thank you, Treasurer. Now, again, to re-emphasize, like I said, there are few individuals who have national attention. They are the ones we know of, because they are known. But there are thousands of individuals, Ugandans, who do not have anyone to speak for them. So who should we leave it to? Who should speak for these individuals? Or who should actually come out to help them? Because they are marginalized, they are indigent, they are vulnerable. So if we do not act, clearly they will remain at the mercy of these injustices that they've already suffered. That's the unfortunate bit. That is why we talked of the demilitarization fund. And also maybe to emphasize that the actions we are taking in respect of the outcome of this court ruling is in fulfillment of one of the 4 Ds, demilitarization, which is one of the 4 Ds of the radical new bar, in fulfillment of our campaign and delivering, but also in fulfillment of our mandate, our statutory mandate under the ULS Act. Now, that said, I'll invite a few questions. So those who have questions regarding the court-martial ruling, you may bring out the questions. Yes, yes, ma'am. You can give her the microphone, state your name, and ask.
Check.
Just a moment.
Good morning. I thought I was allowed, but I don't know. Okay, I have two questions. One for the Vice President, another one for the head finance. I would like to know, following the decision of the Supreme Court justices, they gave orders and declarations. Because as we speak, the wife to the retired Colonel Kizza Besigye filed a suit asking the immediate release of her husband. That was yesterday. But I don't know how people interpreted I don't know what is the take for Uganda Law Society, how people interpreted the decision and even the orders, whereby some of them are saying people should be released, not even transferring the files to the DPP's office. I don't know the take for Uganda Law Society. Are you in support of that? Because if you see lawyers, when they are talking about these issues, they have contradicting views on how the orders were made by the Supreme Court. I would like to know, what is it all? Do you want the people to be released according to the order? Do you want the files to be transferred as it was directed? I don't know which is which. Because the public is listening. You are at the apex of knowing what does the law say, how to interpret these things. I may know, but someone deep there in the village in Nakapilipilit is asking, is it releasing these people, as others are saying that let them be released? Others are saying, is it just a matter of transferring the files to the DPP's office, of which some lawyers who have cases and pending files with their clients are contesting. Another thing is about the finance, head of finance. You've talked about the demilitarization fund. One would like to know how much do you want, because you talk of getting the funds for these people so that they can be released. One would like to know how much do you want? What is the target to see that you help those people? I thank you.
Thank you. David Ijo is my name. I work with NTV. My question is just an emphasis of hers, the very first question she put across. We want to understand exactly from your side what is the law and what is the right thing supposed to be done following the Supreme Court judgment. Because it is now about 5 to 6 days since the judgment, and we are seeing lawyers from different sides. The lawyers of Dr. Kizza Besigye on their part pushing for a habeas corpus. Similarly, those of the National Unity Platform supporters. We just want to understand that. What does the law say? Are they supposed to be released? Are they supposed to be taken to the ODPP? Just what is the law? Yeah.
Another question, members of the press?
All right, is that all the questions? Now, thank you very much for the questions. Most of the questions you've asked really are an outcome of our statement and our position. I'll allow the treasurer to answer, then President will come in to clarify, to add on our position and clarify on some of those areas. Treasurer.
Thank you so much. When you talked, the lady who asked the question, I hope you're listening. When you talked about the issue of head finance, I almost called head of finance Uganda Law Society. Yeah, we have a separate office.
Not in the house.
Yeah, though it's not in the house, but I will answer. We are getting data. We are requesting for data from the military courts, from Uganda prison, and other stakeholders that have been involved into this whole quagmire of trial of civilians in military courts. the number or the information that we shall receive will be the basis on which we shall have a clear picture of the amount of funds we shall need. And of course, individually people have suffered. People have individually suffered under the military courts of law. So that is also information that we shall be getting from the members, the people that have been subjected to this individually. So that will form the basis of the figure that we shall be talking about. Of course, generally, we have a picture of around 10 billion Uganda shillings, generally. But once we have that data, we shall be able to conclusively state the amount of funds needed to ensure that at the end of the day, people get justice. So in due course, once that information comes in, it's coming through. We have already started inquiring and we're getting information. We shall be in a position to confirm that. I hope that is clear enough for you. All right. Yes, Mr. Vic.
All right. Thank you, Treasurer. And maybe to sum up, the launch of the demilitarization fund, we'll have clear figures and a clear picture of how much we require and for what exactly, which is going to be soon because, like he said, the information is coming through from our interventions. The interventions we are taking now is for information gathering. Now, I'll take this opportunity to invite the President, Mr. Isaac Semakade, to add on and also answer for you the two questions from the two media personnel, probably to your satisfaction. Mr. President, you're welcome.
Deborah, thank you for that question. The Supreme Court judgment did not go far enough to specify the individual, the outcome for each individual affected and caught up in the dragnet of military justice. It was clear only for those who had pending trials, pending charges, and thought they would be reappearing before the military courts. Those have clarity, some clarity, that they will now be appearing before civilian courts. However, it is fraught with confusion insofar as it states that there shall be a transfer of cases from the military system to the civilian system, and there shall be an intervention of the DPP. It's also fraught with confusion and some, honestly, chaos when it categorically says that there is a class of citizens that won't benefit from its declaration. All those whose situation had been conclusively dealt with before the 31st of January. So we have constituted a think tank to review this judgment and advise us on how to deliver customized justice for each individual, each victim of military justice as things stand. Because that's the duty of the bar in terms of Section 3, subsection D of the ULS Act. We must account to each member of the public. We must ensure that each member of the Uganda public gets the best treatment under Ugandan law, that Ugandan law is administered fairly and justly in respect of each individual without discrimination. Again, under section 3, subsection E, it's our duty to assist the courts and the government in the proper administration of law. So the enforcement of this judgment in clear terms for each individual is our responsibility as the bar. And we have constituted an advisory team to give us a roadmap for each individual's case. What we know so far is the following, that there are individuals that have counsel. For instance, the petitioner or the respondent in the case, Michael Kavaziguruka, and some of the highly visible individuals you know of who already have counsel. Their counsel are ably competent to process a pathway to justice for their clients. And I think you cited an example, that there are those who have taken the route of putting before the High Court an application for habeas corpus. A habeas corpus application asks one question before the court of law: what is the legality of the detention of the subject of this application? How does the government justify continued detention of the subject of this application? And then there will be a contest in respect of that particular person. Our case is that those individuals have some privilege. They have a friend, a relative who has some means to engage private counsel to put before the courts of law a habeas corpus application. Habeas corpus is the most significant right in the Constitution. It makes the High Court an investigator on behalf of every person whose detention, whose liberty is presently deprived by the state or some other authority, or even some other person, including a child, I believe. A child who is not in the custody of his mother, can be the subject of a habeas corpus application. Who was, under what law is this other person in custody, in possession of this child? So, that complements what my colleague has said, and the treasurer has said, that it's not yet uhuru. This Supreme Court judgment falls in the what Swahili would call nusu mukate. It provided an interpretation of the law which is resounding. The end of civilians before military courts. That era is over. But as to whether it gave effective remedies for the victims of a system of justice that has been found unconstitutional, that's debatable. And in due course, not so far from now, our think tank will have provided a thorough analysis and a pathway to justice for each individual. So that process is ongoing. It's expensive. It involves, as the treasurer said, accessing data. We want to be able to put a name, a face, a story to each individual. They shouldn't be mere statistics. We should know them. Some of our legal aid projects, especially in the hot zones like Karamoja region, have started to give us data sheets of their clients. Those they can account for, but even that data is subject to the qualification that there are many they can't account for. So military justice in Uganda was accompanied by another violation known as enforced disappearance. I mean, the military had no business in the first place arresting Ugandans. They don't have the power to do that. All right? So all those arrests were illegal. The detentions were illegal. The trials were illegal. Was the Supreme Court correct to say, let's close the curtain and move on? That's a question for our think tank to answer. And we shall invite you, not so far from now, to provide you this answer. But you're correct. The country is now celebrating Nusu Mukati. And that doesn't provide relief and closure for so many Ugandans. That's why we are addressing you now and saying that we are reconstituting ourselves completely as a clinic, as a legal aid clinic of a special nature to address the outcomes of the Supreme Court judgment. I hope that answers you fairly. All right.
Yeah. Is that a question, I think?
Thank you so much, President. There are some questions coming online.
Adam, just a moment. His, I think, is also answered. Yours was, what is the law as it stands now? And I want to believe that the explanation given by the President has somehow, or has answered your question as well. Oh, thank you. Adam, you may proceed.
Okay, thank you so much, President and VP. There is a question online, which is almost the same as Deborah's question, but this one is asking, was the Supreme Court clear on where the convicts in the court-martial should go? Should they be set free, or should they go to the civilian courts? What is the basis of this, and what does the law require? Remember, the DPP did not sanction these charges. And then another one says this question goes to the treasurer, that is Collins Mutumba. This goes to the treasurer. How broke is the bar? Please set a figure. Secondly, why is the bar looking for money? How did we get here? And then the last question comes from Jeremiah Sekabira. Jeremiah asks that what is the future of law practice? I think this regards digital transformation as the Radical New Bar agenda. What is the future of the legal practice in light of the advent of artificial intelligence that we saw our president launching? Are our jobs safe? Thank you so much. Those are the responses coming online.
Maybe before we go back to the law, Treasurer, you can come and speak.
Council Collins Mutumba, what do you want to cause to Uganda Law Society? Of course, you may not know, but let me inform you. We have so many dates. Yeah, we have dates with, we had recently an AGM that happened in Munyonyo. We have the diary issue and so many others. So I think it wouldn't be very prudent to mention how broke we are, because we even told the people demanding ULS that they should hold on. Please hold on, we are looking for money. So imagine a situation where you state that we have this much, yeah, they would say cancel. But that aside, we reached here because of, why did we reach where we are? Why do we say the buy is broke? There was an issue of poor planning. The planning wasn't as good as it should have been. And that is why currently we are setting into motion. We are hiring an internal auditor. We are hiring a procurement officer to ensure that we are perfectly in shape to handle the finances of the society. That is how I can answer that question that has been asked by my colleague, Councillor Collins Mutumba. But I have, in private, you can always come and I give you a better picture of the finances of the society. Thank you.
Maybe again to compliment Treasurer before you leave. I think our colleagues may not know that we stand in the unique embarrassment of being a statutory authority, a body established by an act of parliament to perform specific functions, such as Section 3C, to protect, represent, and assist all members of the legal profession. That is, practicing advocates, academics, students, in all conditions of practice or otherwise. That's a very broad mandate. As long as you're concerned with the legal profession, bailiffs, clerks, we are statutorily obliged to protect you, assist you, and represent you in every aspect of your engagement with the legal profession. 3D, to protect and assist members of the public in all matters touching on the law, ancillary to the law, and affecting their engagement with the administration of law. So, we are the Mulago Hospital. We are the national referral law firm for all members of the public. For any reason, we do not question why you have come and chosen to run to the National Bar Association with or without your lawyer. And many people do expect us to be a public watchdog as far as the administration of law is concerned. And 3E, to assist and advise the government and the courts of law in the administration of the law. So again, the state has given us these responsibilities. But even without the state, we would have these responsibilities as the National Bar Association arising from the right to a fair hearing and its interpretation in terms of the UN standards for independence of the legal profession and the IBA standards for independence of the legal profession. The UN instruments, I think the most important instrument is the UN, basic principles for the role of lawyers. This is the 1990 agreement. We call it the Rome Agreement. We also have a Rome Treaty. So both the UN and the IBA, the International Bar Association, met in 1990, August to September, and agreed that every country that follows rule of law must have an independent legal profession. Now, that entails certain duties. The unique embarrassment is that we are not funded by the state. We must be funded independently. We must be independent of the state. We must be jealous about our independence. So we must not accept money that can affect independence of the bar. And that's why the state hasn't funded the Uganda Law Society directly. So we don't receive a subvention from the National Treasury to do these important duties. Yet we are expected to be available at all times as public watchdogs in all facets of legal administration. That requires individual lawyers to pay for the strength and independence of the legal profession. So lawyers up to now are charged fees by the National Bar Association to enable us perform functions 3A and 3B, and maybe minimally 3C. 3A and 3B are about, our role in facilitating their enrollment and their ethics, their continuing professional development, and their dinners and community. So members can understand the 500,000 shillings they pay for that purpose, they have also been gracious. They are paying up to 500,000 shillings for the ULS House Fund, in addition to subscription. So they are paying for the ULS House Fund. That's a specific fund. We can't touch that money and say we're applying it to these clinic duties. No, it's for the ULS House Fund. Members desire to have their headquarters in Kololo. They have approved plans and so on and so forth. So the other thing they are paying for is benevolent fund. Yeah, health and benevolent fund. They pay some 75,000, I think, which is again earmarked for that purpose. So we are not yet there. We recognize the harsh conditions of practice in which our members generate the income which they share collectively to perform this statutory function. It's just not enough. We already have an existing legal aid project which our members have paid for through toil, sweat, and blood, and with the assistance of initially sister bar associations. The Canada Bar Association, I believe, was among the earliest supporters way back 1992. Yeah. The Norwegian Bar as well supported, and then over time, institutional and governmental support has provided us a resource envelope to maintain our legal aid project. But institutional and governmental support towards our legal aid project is earmarked for specific legal aid units or legal aid clinics in specific districts addressing specific situations. So if we have emerging situations like this judgment that fundamentally alters the justice architecture for this country, we have to have new conversations about whether the existing rota of donors to our legal aid program want to support this new intervention. That's a conversation that they must come to willingly and voluntarily. And maybe they are understanding and studying this decision. But we have to lead. Whether or not we have institutional or donor support from development partners, we have our best assets, and that's the goodwill of our members, who require us to have direction, to be clear on what our priorities are as a governing council, and tell them that we are inviting them to direct their advocacy in a particular field. And that's what we are doing, though we know that this is not an ordinary cup of, this is not anyone's ordinary cup of tea. And until the military and the security establishment and the government take a more benevolent attitude towards the judgment that just came, it means there's going to be further contest. The Supreme Court decision has not resolved everything. Clear? It's not yet uhuru. This is half a loaf. It's better than no loaf at all, but it's still half a loaf. Okay? So, to walk the last mile for each victim, and some of the victims are long dead, but they are still victims, and the trauma and the scars have been felt by people who still live, and they want redress, they want reparations. This judgment is a Pyrrhic victory for them. Okay? It sounds nice in legal rooms like this, but it doesn't address the injustice of they came into our home in the night, terrorized us, and held us for days on end. Where is the justice for that? So that's our inquiry. It's a national inquiry, and it would be wrong to just bury these injustices and move on. As the National Bar Association, we are taking the policy decision that we welcome the Supreme Court decision for clarifying that aspect of the law on jurisdiction, but as far as effective remedies are concerned, that's a whole new war zone. And we have to prepare a war budget for our warriors. And that budget is significant. It far outstrips what the Legal Aid Project has received before. I think that's the haircut figure. That's the ballpark figure. Deborah, to help you understand, that figure is in the range of what we have been receiving for the Legal Aid Project, give and take, or for a special project like building this house. You know, the cost of providing redress to all victims of military justice for the last 30 years since the establishment of the UPDF is honestly earth-shattering. And we shall be guided, as I said, by the members that have agreed to sit with us and think through all the options we have and budget it accordingly so that we can have structured conversations with well-wishers from the public. The question about the legal clarification, I think we've said this enough. Take it home. The court was emphatic, 100%, that there shall not be another sitting of a military court. I think not only for civilians, but also for military officers. Not another. They could sit if they want to decide the question of dismissal. That power is still theirs. But criminal justice, everything has now to, they must use the ordinary courts. Now, I think somebody raised the question, is the DPP properly empowered to squeeze herself into these cases and purport to continue them? The short answer is no. No. Civilian justice starts from police, first information. So all these cases, if they are to be transferred, they can't just be leapfrogged into court. If they do that, we are going to challenge that as the National Bar Association. Civilian justice starts with a first informant reporting before a police station. It doesn't matter who you are, whether you are the president, whether you are the head of intelligence, civilian or military intelligence, you must report to police. And the police must conduct a fair investigation. And the police cannot start by detaining people. So there is, in that respect, the judgment has far more, it raises far more questions than answers. And we don't want to use today's forum to speak in very conclusive terms. We have a think tank that has asked for some time to process clear answers to these questions, and we shall review those answers. But the other reason why we don't want to be very specific in how we open up this can of worms is because we don't want to preempt the institutional engagements we are going to have with every department of government concerned. Hopefully, the clarity will come from the government itself. It will come from the DPP, from the police, from the civilian authorities responsible for justice. So we want to give them time as well to reflect through the meaning of the judgment and the obligations they now have towards each victim of military justice. We hope to speak after them, but we will not be waiting forever, okay? If they have no clear answers for the taxpayers, within 1 week, we will be back. We'll be back, and we shall be very bold and vocal, as usual, as you've come to expect of the Radical New Bar. I hope that satisfies Q&A, and we'll close this business. Any other question? Don't have to be... Yes.
Good afternoon to everyone. My name is Counsel Edwin Tobias. I'm working with Zika Advocates. My question is, what is your response to the president's statement? Because we saw the president coming out to undermine the decision of the judges. He also undermined the rule of law. He undermined the principle of separation of powers. So what is the Uganda Law Society response to that? A friend of mine called Brenda Jiduda has also sent a question asking, when are we having a real CEO? Because we have an acting CEO, but when are we having a real CEO for Uganda Law Society? Thank you.
Thank you. Is there any other set of questions before we close this session?
Yes, okay, thank you so much, President. This question comes from WBG iPhone, that's the name he uses, and he asks something related to Parliament. What would be the remedy, additionally, if it's possible for Parliament to pass laws in future that allow General Court Martial to try civilians? Would this be legally possible and okay? That was the question.
So I want to start with the question of the CEO, Mr. Tobias. I think that's a matter for the Governing Council, all right? Yeah, we will, in due course, as guided by the matters upon which we are briefed, provide a pathway to a substantive CEO. Yeah. But we had a retreat last week, yeah, to look at the institutional management architecture for the institution, and in due course we shall communicate outcomes, yeah, after doing that important house cleaning function. So members should not be so anxious. It's a non-issue. It's not out of the norm to have an acting CEO. The second question is Tobias, there is no such statement from the executive, okay? And so we shall not comment about non-existent things, all right? Yeah. Yeah. Well, yes, you should be very worried about the future of your profession in light of AI, and lawyers who are not using AI should be condemned to the dustbin of history. Okay? So, but to help ensure that you still have a legal profession and you're still active, we have again convened a think tank that will guide the transition. Not only for the bar, but also for the judiciary and the government to operate alongside AI as a multiplier force in the delivery of justice. The government, more than a decade ago, passed e-governance laws, but it hasn't really started to implement them to the satisfaction of the taxpayer. The taxpayer is paying a lot of money to e-governance programs, but there's little accountability. So any lawyer out there worried that e-justice would erode or degrade the legal profession should drop that sort of mindset. They should become perpendicular with digital transformation, but they have no cause to worry. The current governing council intends to assist them fully become compliant and perpendicular and alive and lively in their profession alongside AI and other digital tools. So again, in the course of time, we will lay out our plans, not only for the immediate short term, but for the medium term and the long term, how to improve legal services using technology. How much time is that? 20 minutes. Okay, so we would like to close the Q&A for now and have the next item. Can I help you, CEO? It's my honor and pleasure to invite our head of the Manager Legal Aid Project, Ms. Sheila Tuliasingura, to come and read our statement on Tarehe Sita. I think we can stay here.
Good afternoon, ladies and gentlemen. As introduced, I am Sheila Tuliasingura, and I will stand on the protocol that was highlighted by our CEO and go straight to reading our statement. That is the Radical New Birth statement on the 44th Tarehe Sita commemoration. Okay, so the Tarehe Sita has over the years become synonymous with fostering better relations between the military and civilians across the country through medical outreach programs and public sanitation activities, these among others. So as we reflect on the significance of the 44th Tarehe Sita commemoration that's happening today at Chotera in Rakai district, we would like to urge the Uganda People's Defense Forces to adhere to the judgment of the Supreme Court in Attorney General versus Honorable Michael Kabaziguruka, which was read last week, wherein the top court unequivocally declared the trial of civilians in military courts unconstitutional. Globally, numerous jurisdictions have transitioned towards best practices that prohibit the trial of civilians in military courts. And I'll give a few examples here. We have Argentina in 1984. They formed a code of military justice explicitly prohibiting military courts from trying civilians. The 2008 reform abolished military jurisdiction over any civilian-related cases. This is in addition to Article 118 of the Argentine Constitution, which provides that civilians must be tried in civilian courts. In Tunisia, their Article 110 of their constitution restricts military jurisdiction to offenses committed by military personnel. Tunisia also set up a civilian military oversight board that monitors and intervenes when civilians are wrongly brought before military courts. Mexico, in 2014, passed the decree amending various provisions of the Code of Military Justice, expressly banning military courts from trying civilians. And this was following several rulings by its Supreme Court. In addition, Article 13 of the Mexican Constitution states that no civilian shall be subject to military jurisdiction. In South Africa, post-apartheid South Africa passed the Military Discipline Supplementary Measures Act of 1999, specifically limiting the jurisdiction of military courts to only South African National Defense Forces members. In Colombia, in addition to their 1991 constitution, they adopted the 1999 Military Criminal Code, which provides under Article 5 that under no circumstances shall civilians be investigated or tried by military justice. And the United Kingdom, trial of civilians in military courts is expressly prohibited, and that civilians working for the armed forces are subject to the specialized standing civilian court established under the 1976 Armed Forces Act. In 2021, Venezuela reformed their organic code for military justice to explicitly prohibit the trial of civilians in military courts. So these examples demonstrate the global trend towards upholding civilian judicial authority as a hallmark for democratic governance and respect for human rights. Article 208(2) of the Constitution of Uganda provides that the UPDF shall be subordinate to the civilian authority as established under this constitution. This is fortified by the fundamental principle that judicial power, as stipulated under Article 126 of the Constitution, is derived from the people and shall be exercised by the courts of judicature in the name of the people and in conformity with the law and the values, norms, and aspirations of Ugandans. So at this critical juncture, the UPDF ought to pause and reflect deeply on the reparations to address the violations that are associated with the trial of civilians in military courts since its establishment in 1995. This action will serve to strengthen the rule of law, enhance public trust, and reinforce national cohesion. Let this year's commemoration of Tarehe Sita be the reaffirmation of UPDF's commitment to constitutional supremacy, upholding the rule of law, and the protection of fundamental rights of all citizens. As the UPDF celebrates Pan-African solidarity and people's sacrifice in the struggle for freedom, democracy, and socio-economic transformation, it must reckon with the fact that true democracy is inseparable from justice. The very sacrifices that built this nation were made to establish a country where no citizen, civilian or soldier would be subjected to arbitrary power. Upholding the Supreme Court's ruling is not just a legal obligation for the UPDF, it is a moral and historical duty to honor the spirit of those who fought for a Uganda governed by the rule of law and not the rule of force. For God and my country, signed Isaac Chimaze Semakade, President, Uganda Law Society. Thank you.
I think that closes item 2. It reminds me of a question somebody asked, whether it's a speculation, whether Parliament or the executive can, in the aftermath of this judgment, simply go to Parliament and get a law passed even tomorrow, authorizing trials of civilians in military courts. Well, you've seen the global best practice, you've seen the global trend. It's towards transition. And Uganda has now joined that river. I don't see the river flowing backwards. I would like to assure you that under our constitution, which has just been interpreted, the Supreme Court has emphasized that trying civilians before military courts has an implication for the right to fair hearing. So any amendment of the Constitution for the purpose of putting a civilian before the military court triggers what we call Chapter 18 implications amendment. And that chapter says anything that affects right to fair hearing requires a referendum. The people of Uganda must know clearly what they are amending the constitution to authorize. And if it touches on how they shall be tried, if it touches on justice, how justice shall be settled, a conflict between a citizen and the state, how it shall be adjudicated before a court of law, that matter requires a constitutional amendment that must be authorized not only by Parliament, but by the people of Uganda in a referendum. So anybody daydreaming about the return of the past must understand that the ultimate crucible, the ultimate yardstick will be a referendum. It will be the people of Uganda themselves to ask for military justice. And honestly, I don't see that happening anytime soon. So this chapter is over. There are some people who are sour graping and having difficulty with acknowledgement and everything, but over time, it will sink in, and it will sink hard that we have closed the chapter and we are moving closer and closer to democracy. Yeah. I think that ends our number 2. What time is it now? 9 minutes to 1. So some friends of ours from NTV, are they here? They've gone out? Maybe I hope that, who asked the question about Parliament?
No, it was online.
It was on
Okay.
housekeeping. We've been asked to do an interview directly on TV with NTV people, so the CEO is trying to coordinate that. But until I am told that it's 1 o'clock and they want us to shift, I think we can go on with the rest of our program.
Maybe, Mr. President, for our Luganda viewers, they would want the translation of what we.
Well, okusooka twagala okuyozaayoza kooti ensukkulumu n'omukulembeze waayo Chief Justice Alfonso Winidolo okutuusa ng'eggwanga ku buwanguzi obw'enkalakkalira bwe twatuuseeko wiiki ewedde ne batuwa ensalawo yannaggomola ku nsonga ebadde efuuse ebbala eri obutujju really okukomya ogwo omuze ogw'okukozesa ekitongole eky'amagye okukola omulimu ogw'essiga eddamuzi. Ekyo nsaba bannange benkola nabo mu kitongole kyaffe ekitugatta nga bannamateeka okukubira Chief Justice ne kooti ye mu ngalo ku nsonga eno, okugonjoola akasambattuko ak'emyaka egisukka mu 25 kikolwa kya nsusso nnyo eri ekitongole kino, era Katonda abongere obugumu mu mulimu gwammwe. Enkola ey'okugezesa abantu ba bulijjo mu kkooti z'amagye ekomye era teridda. Ekyo twagala okukyakasa, teridda kubanga ensalawo ya kkooti gye twafunye ekakasa nti balina okusaba Parliament ekyuse ssemateeka bw'eba eyagala kikomewo walina okubaawo enkyukakyuka mu ssemateeka ate enkyukakyuka ezo mu ssemateeka teziyinza kufuuka teeka nga tebeebuuzizza muntu wa bulijjo mu kakonge mu referendum. So asuubira nti enkola egenda kudda mwaka gujja oba very soon ali mu birooto eyo enkola ewedde. Ndowooza muwulidde ekiwandiiko kyaffe ekiraga nti ensi nnyingi ezaalina enkola ezo ezaalwanirira oba ezaagirwanyisa zaatuuka ne ziraba nga tekikyagasa kusika muguwa ku nsonga eno ne bakyusa ssemateeka waabwe ne bakyusa amateeka gaabwe ne bagaa nti entegeka okugezesa abantu ba bulijjo mu kkooti z'amagye kirina okukoma era baakikomya. Era ku luno olunaku lwa Tarehe Sita, olunaku olw'omugaso nnyo eri amagye gaffe, tubawadde obweyamo okubayambako okweyongera mu maaso butadde mabega, okweyongera mu maaso okujaganya naffe ku buwanguzi buno, kubanga kino kituwadde kitadde ku maapu ng'eggwanga, ku maapu y'ensi eziteeka demokrasiya ne ssemateeka n'eddembe ly'obuntu bulamu ku mwanjo. So ekitongole ky'amagye kijja kulabika bubi nnyo bwe kinaaba nga kyagala ate okulwanyisa ensala eno. Eno ensalawo ebawadde ekyokukola, temuwuliriza abo babawaga okuva ku mulamwa. Eno ensalawo erina okuteekebwa mu nkola embagirawo. Ensalawo ya kkooti ensukkulumu teteesebwako. Tubasaba nga ekitongole ky'amagye mwekube mu ttooki muyimbule buli muntu yenna owa bulijjo abadde agezesebwa mu kkooti zammwe ez'amagye. Mulina okuyimiriza ensala ezitannaggwa ez'abantu ba bulijjo mu kkooti z'amagye. Mulina okusengejja buli musango gw'omali mugudde ku muntu wa bulijjo. Emisango egitalina nsa mugikomye. Temulinda DPP kukibagamba, temulinda Uganda Law Society kubaloopa mu kkooti. Emisango egitalina nsa mugikomye. Egyo emisango egirimu ensa mugende mugiroope ku poliisi ng'omuntu wa bulijjo, ng'ekitongole kyonna bwe kirina okukola. Poliisi etandikira awo ng'abantu abo bonna bayimbuddwa bwe kiba kyetaagisa okwongerayo emisango egyo. Mulina okwekenneenya era mwejjukanye emitendera egy'omunda egy'amagye okuziyiza okutyoboola eddembe ly'obuntu nga mugenda mu maaso. Mulina okukomya Supreme Court, kkooti enkulu kyebaziyizza okuddamu mutakola. So n'olwekyo ffe ng'ekitongole ekigatta bannamateeka tugenda kukolera wamu n'ebitongole bya gavumenti byonna okutandika n'ekya Ssaaba waabi w'emisango ne Ssaabawolereza wa gavumenti n'olukiiko lw'eggwanga olukulu olukola amateeka. Kano ke kaseera k'ebikolwa by'amateeka ebizimba eggwanga. Ensobi eyakolebwa mu 2025 erina okukoma kati. Ensalawo etuwadde ekyokukola era mbagirawo mukole ennongoosa mu tteeka lya bannamagye litandika okutambulira ku nkola za ssemateeka. Olujegere lw'okutiisatiisa abantu ba bulijjo, okubasirisa, okubakanga nga mulimu n'okubuusa amaaso enzibira za ssemateeka birina okukoma olunaku lwa leero. Tusaba tukolere wamu ffenna ng'Abannayuganda mu kuteeka mu nkola z'amateeka n'enfuga y'amateeka. Tulina okulabula eri abo abali mu gavumenti abalowooza nti etteeka essukulumu erya Uganda si ssemateeka wabula buyinza bw'amagye. Eyo ndowooza nkyamu era tugivumirira nnyo luno olunaku lw'abamagye olwa Tarehe Sita. Etteeka essukulumu erya Uganda ye ssemateeka so si buyinza bw'amagye. Njagala tukomaawo for now. Yes. Please. N'obwennyamivu bungi nti ensalawo eno wadde etuwadde ekitangaala ku ntaputa ya ssemateeka teyatunuulidde embeera yaabo buli muntu mu butabalika bw'Abannayuganda obwakosebwa enkola eno. Kkooti ensukulumu yenyigidde nnyo ku tambula mu kudda mu maaso ebyemabega tubyerabire. So ekintu ekyo kireeseewo obuzibu mu ntaputa ya ensala eno nti kati abantu abali mu kkomera balina kuteerebwa mbagirawo oba balina ekirala kye balinze. Amazima gali nti abo balina ba looya baabwe bo beesiimye balooya baabwe bayinza okubayambako okutegeera okutaputa ensala eno n'okubayambako okudda ewaka. Naye abatalina ba looya be tutunuulidde ffe nga ekitongole kya Uganda Law Society tutandise okusaba information ebibakwatako okuva ku Uganda Prisons ne UPDF okutuwa amannya gaabwe ne uwa gye bali. Tutandike okubakyalira buli muntu kinoomu okubanyonyola nti ensalawo eno eyavuddeyo wadde eggyeewo ekkooti z'amateeka naye basigadde mu system, basigadde mu lunyiriri lwabo abalinze olunaku lw'ekkooti. Ge mazima kyennyamiza naye tusazeewo okutandika ku olutalo olw'okuyambako abantu ba bulijjo abali mu mbeera eno. So treasurer waffe mumuwulidde atugambye nti ffe kye tumanyiiko okuva kwebyo kuba tulina legal aid clinics nga 26 mu ggwanga lyonna, zitulazeeko ekifaananyi ekitono ku mulimu oguli mu maaso. Naye bwe tubalabalamu nti eno enkola ebadde etyoboola eddembe ly'Abannayuganda okumala emyaka 3, abantu betusuubira okujja okutusaba obuyambi, omuwendo gwabwe tegunnamanyika, naye tumanyi bajja kubeera bangi basinga ba clients betulina kati. So tutaddewo enkola ey'okuteekawo fund, okuteekawo ensako ey'enjawulo enaatuyambako enatuyambako okubadduukirira. Balooya tubalina, naye transport waabwe situmira, emmere yaabwe situgiina, kalaamu ne peni ze beetaagisa situbiina, obudde tulina obusasulira singa beewaayo okutuyambako. So ebyo tugenda okutunulamu kutandika ne leero, tufunyeeyo ba consultants abagenda okutuyambako okudduukira omuntu wa bulijjo, naye nga tujja kudda mu bbanga eteri lyawala nnyo okubannyonnyola nga tumaze okulaba ebitongole bino, okubannyonnyola biki bye tugenda okukola okuyambako buli muntu okudda ewaka. Tusuubira nti DPP, Attorney General, betuyita civilian authorities bagenda kukozesa bwerufu na mazima okutaputa ensalawo ya kkooti, babulire abamagye ekituufu ekirina okukolebwa, era batandike bo bennyini nga situbasindise okufulumya abantu ba bulijjo mu wiiki emu oba 2. Bwe kinaaba kibalemye tujja kudda tubabuulire nti ffe nga Uganda Law Society bino bye tugenda okukola okulaba nti buli omu wekikwatako asobola okuddamu okufuna eddembe lye mu ssemateeka. So kangende ndowooza we were going to have a small break. Is it still necessary? Last item of our program today, which is again connected to this. This one is, I'm in charge of it. But before I do so, I want to introduce once again some of our guests. Please come to the podium. I want to start with the President of the Uganda Law Students Association, Ms. Angela Namuleme, and the Speaker, Mr. Kuganja Joel. Kuganja Joel. Come this side, Jovan Joel. Mr. Kuganja Jovan Joel is the Speaker of the Uganda Law Students Association and the President of the Nkumba University Law Society. Ms. Angela is the President of the Uganda Law Students Association and also the President of the IUIU Law Society at the female campus. Where is that? Yeah, in Kawaja. I have a joke with them that it's in Natete, but they like saying Kawaja. Okay. We also have a third guest, Mr. Trevor Muholi. Trevor, you can stand up and wave. Yeah. Yeah.
Law Students Association.
I have to go. Oh, yes. Where is he? Yeah, I'm also informed that we have Mr. Mwanje Gideon, the president of the East Africa Law Students Association. You can come and join us here. Yes. Yes. It is important that we involve law students in national affairs so that they can maintain the tradition of marching the whole nation, leapfrogging the whole nation into democracy and constitutionalism. So it's my honor today to speak to the launch of a high-profile case unit of the Uganda Law Society. Our justice system stands at a watershed moment. The foundations of the rule of law, that is judicial independence, advocate autonomy, and access to justice, face unprecedented systematic challenges that threaten to unravel decades of institutional progress. This crisis manifests not merely in isolated incidents, but in a calculated pattern of actions that undermine the very fabric of our legal system. This week, we meet on a more light-hearted tone. We stand on victorious ground. We are celebrating the triumph of the rule of law. But don't forget that just last week, and since we were elected on September 28th of last year, we didn't stand on victorious ground. We stood on much anxious ground because the events that punctuated our campaign, they paint a disturbing picture. Let me just give you an example. At the time we came into office, this is what our membership was disturbed by. Number one, extreme dissatisfaction with the regulator of legal practice and legal education, the imposter, as you know, as the Law Council. State security operatives interfering with lawyer-client relationships, especially in politically tinged cases. I think you saw that vividly. The concerning trend of advocates facing criminal charges for representing their clients. Almost every week, the Vice President and I are asked to rescue an advocate from a police post due to interference in the advocate-client relationship. Increasing reports of surveillance and intimidation of law handling sensitive constitutional matters. The growing reluctance of law firms to take on cases challenging state power due to fear of reprisal. Systematic attempts to influence judicial appointments and decisions. The emergence of parallel legal structures that bypass judicial processes. This is a common theme across the country. People speak of RDCs and unit this, unit that, bypassing established processes. So, simultaneously, however, a critical gap has emerged in public interest advocacy. While we have a legal aid project that has admirably served the most indigent of our population, numerous pressing public interest matters affecting broader segments of society remain unaddressed. I'll give some examples. Law Council backlog that affects consumers of legal services and legal education. Who is doing anything about that? Who should do something about that? These were the questions we were elected to answer. Judicial Service Commission ineptitude that erodes public trust in the judicial system. These are concerns we can't put to lap. You know? Constitutional challenges affecting business communities and middle-class citizens are beyond the remit of our legal aid project, which is solely focused on the indigent segments of our society. Environmental protection cases impacting entire regions. I don't think our lap is involved in abuses of power around ECOP and other environmentally sensitive projects. No. Tax justice matters affecting the formal sector and businesses. I think last year we saw the IFRIS demonstrations. Those are matters beyond our lap, as it's currently structured. Digital rights and privacy concerns touching all segments of society, especially your agents. Land grabbing cases affecting both the wealthy and poor communities. Professional bodies seeking judicial review of regulatory overreach. I think in our first Rnblive we had Bailiffs Association saying they have not been served for more than 4 years now. They can't even access the Chief Registrar or the Chief Justice. And yet they are affected by regulatory overreach, as they ably articulated it. Public procurement transparency cases. Government contracting is meeting with public criticism and condemnation, and we are expected as the law society to intervene, but our current interventions are contained in the lab project, and they are falling short in a number of ways. Pension and social security matters affecting formal sector workers. Just yesterday, I think I saw an advisory from the Attorney General concerning the rights of former UNRWA workers and other workers who are going to be laid off due to the government's program known as RAPEX. Do you know RAPEX? Well, the government is restructuring its agencies and its public expenditure outlays and a program called RAPEX. They call it downsizing government. Yeah. The number of views that you should take interest in as both the Uganda Law Students and East Africa Law Students Associations, whether there is fairness and rationality in how government is going about downsizing. The Uganda Law Society finds itself inadequately equipped to respond to these challenges. Our lab, that is the legal aid project of the Uganda Law Society, is overwhelmingly donor funded, but its mandate specifically focuses on vulnerable and indigent populations. This creates a significant void in addressing public interest matters affecting the non-indigent and our institutional stakeholders. This limitation severely restricts the Law Society's ability to fulfill its statutory obligations, particularly under sections 3, subsection C, representing members, D, representing the public, and E, advising and assisting the government. These mandates call upon us to be innovative. Most critically, the ULS presidency, which is the spearhead of the bar is tasked with leading the society's response to all these challenges, but it lacks the institutional infrastructure and resources necessary for effective intervention. The President's role, though powerful under the ULS Act as affirmed by the decision of the Court of Appeal in Chaudhry versus Attorney General, remains largely ceremonial in practice due to resource constraints. This hampers our ability to mount rapid response to emerging threats and against advocates, to engage in strategic litigation to protect constitutional principles. Let me explain this more clearly. For so many advocates, members of our ULS, members of the public, members of the judiciary, the Uganda State President must not even sleep. They must be engaging 24/7 with everything that Ugandans see on TikTok, WhatsApp, TV, radio, and the newspapers. Correct? And if they don't hear our voice or my voice in this situation on any of these issues in real time, the immediate response is we have betrayed them. Now, we don't want to engage in he said, she said, but at a structural institutional level, it means that the office of the President of the Uganda Law Society has grown in stature and in national stature, and people expect it to be appropriately resourced to meet these expectations. The truth of the matter, though, is that it's not yet there. Okay? I think it's a testament to the success of LAP that people think the LAP program is as vast as the office of the Attorney General or the Director of Public Prosecution, that you can go pound for pound with these offices, which is probably not right, not true, not correct. We cannot, for instance, competently provide institutional support to law firms facing state pressure. The lawyers who elected us expect us to bang the table. But what does banging the table mean, For some, it means demonstration of utmost frustration with their present anxieties, being centered. But for others, it means truth-telling. For others, it means articulating both redress and reform. So it means many things to many people. Our concern in Council has been that we have to complement LAP to address these emerging challenges. For instance, we are asked every now and then to coordinate systematic documentation of rule of law violations. But the only capacity we have is our rule of law program, which is staffed by 3 people to serve the whole country. We are daily asked to maintain consistent advocacy on judicial independence. And not many lawyers want to stand in this program. That's why we have said, let the lawyers elect their judicial watchdogs. Because if we were to ask them individually to accept these roles, they wouldn't want to step on toes. So we are asked to play a role of stepping on toes of judges daily, to pursue public interest litigation affecting both the indigent and non-indigent populations. My friend Mr. Igesa calls it reverse lawfare. We are expected to be engaged in reverse lawfare against those who commit the most heinous abuses of the Constitution. We are expected to challenge systematic issues concerning broader segments of society. Taxpayers. I think recently the IGG had a report on Ugandans who have lost money through condominiums and other scams, online scams and so on and so forth. Lastly, professional bodies and other institutions expect us to walk the path of reform alongside them as their professional legal, as their go-to legal advisors, and to be aware of and to help them set precedent in courts of law where they have failed. So against this background of claims and expectations, we have taken the decision as the Radical New Bar Governing Council to establish what we have called a high-profile case unit, which represents a strategic solution to all these institutional gaps. As a specialized department under the Office of the ULS President, it will serve as society's rapid response mechanism for cases and issues that threaten the administration of justice, but also fall outside the traditional legal aid parameters. The high-profile case units, which we shall call the HPCU, will focus on some of this work, and I'll use examples to bring it out. Defending advocates and law firms facing persecution for professional work. If we were to use the current resources we have, that's the lawyers from LAP, we would be denying the most indigent a lawyer to defend lawyers. Does everybody see the conflict? We have just enough lawyers paid for by donors to respond to specific indigent segments. But our own members face challenges in conditions of practice, and they require legal representation from the bar. Lately, council members do this role, but it's not sustainable. We have to have an institutional mechanism for that. Challenging systematic attempts to undermine judicial independence. Now, threats to judicial independence come in all forms and shapes and sizes, you need a constant watchdog. Currently, we don't have. Intervening in precedent-setting cases affecting rule of law. How do we process decisions to intervene in? Our members have committees and clusters, and they use their agency to reach out. But once they provide us this information, how is it processed into action without burdening our existing minimal resources at LAP? Providing institutional support for the ULS President's statutory mandate, coordinating responses to emerging threats against the legal profession as a whole, not just emerging threats, but even traditional threats to the independence of the legal profession, like the Law Council, which currently ring fences duties we should be conducting ourselves here, like enrollment and discipline. Taking on public interest litigation on behalf of the non-indigent professions as well. I mean, not everybody wants to stand in the position of challenging governmental abuse. It takes a toll on anybody. So there's the expectation that the bar should be more visible and more operational on that front. Supporting professional bodies as well in matters of public importance. So the establishment of the HPCU for these reasons is not merely desirable, but it is essential for ensuring comprehensive access to justice across all segments of society. Without it, without this unit, the ULS risks becoming increasingly irrelevant in the face of mounting challenges to the rule of law, potentially failing in its statutory duty to protect both the profession and the entire public interest, not just the indigent. The HPCU will help us bridge the critical gap between the mandate of the Law Society and the current operational capacity, as well as national expectations, ensuring that Uganda's premier legal society can effectively respond to contemporary challenges while building resilience against future threats to judicial independence and professional autonomy. The HPCU will ensure that public interest advocacy extends beyond traditional legal aid boundaries to serve all segments of the society requiring protection of their legal rights. At this juncture, I would like to introduce Mr. Trevor Muholi, who is going to be our inaugural director for the HPCU. Trevor is not a lawyer. Trevor is a citizen, like all those who have been making these demands upon us. But we are saying, well, instead of criticizing us from outside, why don't you come inside and see what you can do on your own? So Trevor, you have the chance to make history as the inaugural director for the HPCU.
Thank you very much.
I've known Trevor since last year. He's a very, very articulate thinker and a critic of our systems. And I do not know any better person to help us in this role than you, for the humility you accepted to come in and make the transition from critic to actor amongst lawyers. Yeah. So we've discussed this. We've introduced you to our governing council before. They have approved what you have to help us with as the bar. This is personal for you. We like that you're representative of the demographics of Uganda. You are among the best and brightest amongst our young generation. So we are eager to hear what you have to say, taking up this role before we coronate you properly as the newest member of the Radical New Bar. So join me in clapping for Trevor. All right.
I prepared a speech for this. I didn't want to be organic. Good afternoon. I'll try to make it as quick as possible. I know you've been waiting through hours. So when I accepted the invitation to lead the high-profile case unit at the Uganda Law Society, I knew I was stepping into a space that demands not just a technical expertise, but a deep, unwavering commitment to justice. This is not just a job, it's an extension of a lifelong engagement with questions of power, freedom, and self-determination. I've spent most of my career interrogating the unspoken rules that shape our society, how authority is maintained, how dissent is suppressed, and how language and tradition can be used to either liberate or contain us. In many ways, I've been an outsider looking in, questioning what is often taken for granted, and so I must acknowledge the radical generosity of the Radical New Bar in embracing this collaboration. It is not lost on me that in a profession that prides itself on its traditions, some of them calcified, some necessary, my background in cultural criticism might have seemed unconventional. That this door has been opened signals something important. that the legal profession in Uganda is willing to engage with new ways of thinking, that it understands that justice is not static, and it recognizes the urgency of its role in a country where the very idea of rights is often contested. Taking on this role means stepping into an established statutory body, one that carries weight, responsibility, and a history that must be reckoned with. The Uganda Law Society, by its very nature, embodies the delicate balance between legal tradition and the fight for justice. It stands as a testament to the independence of the legal profession, an independence that is not just theoretical, but is now lived, defended, and reaffirmed every day by those who refuse to be co-opted, those who insist that the law must serve the people, not just power. This moment is bigger than me. It's about what it means for an institution like the Uganda Law Society to establish a unit like the HPCU in the first place. It's an acknowledgement that legal battles are not just about technicalities. They're about shaping the society we want to live in. The independence of the legal profession matters to me because it ensures that justice is not a favor to be granted, but a right to be demanded. That independence is what allows the rest of us to stand up for those who challenge power, for those who speak truth that others would rather silence, and for those who dare imagine something different. The 1995 Constitution was meant to be a turning point, a break from colonial legal frameworks that were never designed to serve us as Ugandans, and yet we find ourselves still struggling with the weight of those structures. The HPCU exists because justice in Uganda is often a contested space, because power resists accountability, and because the legal system itself must be constantly interrogated and pushed to serve its highest purpose. This role for me is about translation, translating critique into action, translating cultural discourse into legal precedent, translating the abstract pursuit of justice into tangible victories for those who need it most. It's about ensuring that the legal profession maintains a space of integrity, courage, and independence. It is about using the law not just as a tool of defense, but as a weapon for transformation. I do not take this responsibility lightly. The work ahead will be difficult, but it is necessary, and I imagine I do not walk this path alone. I'm surrounded by all of you and the generosity of the bar. To those who have welcomed me into this space, who have chosen to stand on the side of justice, even when it's inconvenient, I'm grateful. To those who believe that Uganda can be more, that our freedoms can be expanded rather than eroded, that justice is not an abstract ideal, but a lived experience, we have work to do. And to those who want to see this intervention succeed, this is your fight too. The HPCU cannot do this alone. We need your voices, your solidarity, your resources, and your courage. Whether you're a lawyer, an activist, a journalist, an artist, or any citizen who refuses to be silent, there is a place for you in this struggle. Show up for those who risk everything to defend our rights. Hold institutions accountable. Defend the independence of the legal profession. And when the time comes, because it always does, stand with us. Let's get to work.
Thank you very much, Trevor. It's a testament, indeed, to the independence of the legal profession that on this auspicious occasion of launching the high-profile case unit, I'm surrounded by not advocates, but future advocates, and you as well, a non-advocate.
Maybe a future advocate.
Maybe a future advocate. Taking charge of what concerns us and binds us. I would like to hear what my co-president thinks about this.
As Trevor has submitted, it is a great impact, I believe, towards the progress of the high case unit. And I strongly believe he's a passionate person to the triumph of this. And I don't know why, but I'm so more trusting. Like with your speech and to the audience, I don't know how you feel about it, but personally, I'm so glad. Yeah.
Yeah, thank you. I mean, it will take outsiders to correct us, our path. Yeah, especially integrating the students' body? Because you've had problems with that before, haven't you? You're reminding us to integrate more and more non-advocates in our programming is what the HPCU actually will lead on. And that's why we invited you to witness this. Before I invite the speaker, let me invite the president of the East African Society, East Africa Law Students Association, a man who is exemplary at lobbying. Is your office in Nairobi? In Arusha, Tanzania. Yeah. Please tell us about yourself, tell us about your game, and what you think about our game.
All right. Good afternoon. I just want to applaud the...
You can introduce yourself again.
Okay. My name is Mwanje Gideon. I am the first president of the Law Student Association of East Africa, an association that was launched last year at Fairway Hotel, and it unites the National Association of Law Students in the various countries of East Africa. I'm so happy to be here to witness one of the great things that we have been looking to see, that at one time we should have a bar that will uphold the rule of law. We should have a bar that will take up the mantle to see that various aspirations of the people of Uganda are put into consideration. That the law, as the speaker has put forward, that should be used as a tool to bring justice, not as a sword to see that various rights of Ugandans are put at a disaster. I'm so happy, and I would like to applaud you, sir, for that great work. And we believe as law students across East Africa, even in our coming conference, because we have a conference next year at the Catholic University of Eastern Africa in Nairobi, Kenya, we would like to have, next month, would like to have this on the front, so that our students, not only in Uganda, but across East Africa, need to know about this high-profile case unit, how it operates, and how it can better the region, not only as Ugandans. For God and my country, may God bless East Africa.
Thank you, Mr. Mwanje. And finally, from the president of Nkumba University Law Students Association, Law Society, and the speaker of the Uganda Law Students Association, Mr. Jovan Kuganja.
Thank you so much, everyone. I appreciate this opportunity, and I really don't take it for granted. Mine will be in a summation, a vote of thanks to the RNB president for giving, and governing council, of course, for giving the young minds a platform. You know, sometimes we forget something that is really important, that we are not living only for today, but the future is there as well. So if we are thinking about the future this early, then it is really a win for the radical new bar. We are here to represent students. We are not representing ourselves. Every president here comes from a university that has hundreds of students. And in the future, near future, we not want to be a part of a bar that is militarized, that is colonialized, that is not transformed. And that is why we are here, to prepare the future for us and for the students that will come after us. Thank you so much, Council Isaac Semakade, for the platform and the opportunity. And I promise you, at least I've heard from his speech, I'm sure that will not disappoint the radical Nyoba. I request us to just join our hands together and applaud Council for giving them people, young minds, an opportunity and a platform to bring new ideas on the move. Thank you so much. I remain Kuganja Jovan Joel, President of the Nkumba University Law Society and Speaker of the Uganda Law Students Association. I owe you.
So perhaps before we close, Trevor, Angela.
Once again, I just want to introduce more to you about Uganda Law Students Association as a body that conveys with all law schools in Uganda. Currently, we are 17 and more. So it is us, the body, that we are leading on different law schools. As he has said, it is a composition of all, like every president in each law society is a member to Uganda Law Students Association, to which we create links for every law society to the law fraternity as we are now. We really appreciate the RNB team and the council for granting us such a permission to engage, participate in our ideas, to that is considered and will be respected, I believe. Representing Uganda Law Students Association as their president, Abnamileme Angela, President Law Society at Islamic University in Uganda, Females Campus. It's so an honor that we've started attending to the series, and this is our fourth. I believe we've started and we shall never stop. Thank you so much, Senior Council. Thank you so much, team, for having us. And onwards, as we're moving on every week, at least one of us will be representing. Thank you.
And Angela, you don't have to come physically. You can be online on Twitter, YouTube, Facebook.
To me, I believe coming physically will do more great work.
So you have to ask your colleagues in Gulu University, Pentecostal University, IUI Mbale, not to miss out.
Something that we forgot to mention.
Yes.
Council Isaac, Senior Council Isaac, sorry about that, is our patron at the Uganda Law Students Association, and we are proud that we have him for such a time. He's really a man for the right season. I know out there some people may understand him or not, but he's a man fit enough for the office he's in, a man for the season. And we are proud as the Uganda Law Students Association.
Yes.
Man of all seasons, not just this season. Okay, unless there are some questions about HPCU, would like to bring this to a close. Any questions? No? Maybe it's fatigue? Okay, it's time to close this, I guess. But one other thing, we are requesting those with cameras and everything to Mr. Vice President, why don't you bring our regalia and dress this stranger? Yes. Yes.
I mean, what an honor.
Yes. Let's just first show it off. So we can start from the back. Yeah. Yeah. Good. Come in. Come up once. Yeah, Rosa, this one. Oh yes, yes. No, you hold this. That's good. That's good. Yeah. We can move closer. Yeah. I think this is it.
I guess one time it should be us.
Yes. And then at the back. Check it. Yeah. Yeah. So you can clap. Okay, Trevor, you can dress up. Yes.
I mean, I was always back on track, but this is me joining the radical new bar.
Congratulations, Trevor. Yeah.
Thank you so much, guys.
Yeah. For the record, we were supposed to do this much earlier in January, but events even more fortuitous happened to make the case for why we need this capacity, this additional capacity to fortify our response. And Trevor, you have to hit the ground flying.
The treadmill
is already moving. So I think the last activities are executive, signing. We can move there now. Yeah. All right. Let's